Hello friends, in the series on income tax cases, today we will discuss a very important case on section 54F exemption and the computation of capital gain when the assessee do have both long-term capital gain on some shares and at the same time the assessee do have long-term capital loss on the sale of some shares. The issue before the Mumbai ITAT SNC bench was that can the assessee claim section 54 exemption against the long-term capital gain, and then the assessee can claim the long-term capital loss if any on the sale of some other shares to be carry forward, or the assessee has to first adjust the long-term capital loss against the long-term capital gain, and then any balance figure comes, then the assessee has to claim the exemption under section 54F. This issue has been decided by Honorable ITAT SMC bench of Bombay in the case of Niklesh Bhagwan Das Mehta versus Income Tax Officer, and this case is reported in 138 ITR Tribunal, short notes 19, and the date of the judgment is 15th April 2026. The present case relates to the assessment year 22-23. In the present case, the assessee has sold some shares, equity shares, on which the assessee has earned long-term capital gain. The assessee claimed section 54F exemption against the sale of these long-term capital gain. Apart from that, the assessee do have some long-term capital loss on the sale of some other equity shares, and the assessee carried forward that long-term capital loss. But when the Central Processing Center, that is CPC, processed the return, that return was processed mechanically and the CPC denied the carry forward of the long-term capital loss on the pretext that first of all the long-term capital loss should be set off against the long-term capital gain, and then the assessee has to claim the exemption under section 54F from the balanced long-term capital gain. But the assessee was of the viewpoint that section 70 subsection 3 permits the assessee to carry forward the loss, and section 45 talks about the computation and the manner of computation of the capital gain subject to the provisions of section 54 to 54H, which includes section 54F also. Meaning thereby that on the conjoint reading of section 45 and section 70 subsection 3, the assessee has to first calculate the capital gain after claiming all the exemptions under section 54 to 54H, and then if any loss remains, then the assessee can carry forward that loss. So applying the same analogy, when the tribunal heard the matter, the tribunal said that in the present case section 45 subsection 5 is applicable, which says that the capital gain is to be calculated subject to what is provided in section 54 to section 54H. The tribunal said that section 54F is subsumed for the purposes of the computation of capital gain, and section 70 subsection 3 talks about the set off of the long-term capital loss from the long-term capital gain subject to provisions of section 48 to 55. So the CPC has erred in not allowing the assessee to carry forward the long-term capital loss. Friends, this case is very important. Again, this case throws light that the capital gain is to be calculated asset-wise and not in totality. In the present case, the CPC has erred in deciding a issue which is hyper-technical also, because these type of adjustments cannot, or these type of carry forwards which are highly technical in nature and which needs the interpretation of the law, should not be decided by the CPC under section 143 subsection 1, because they are because the CPC calculates the things in a very rough manner without going into the law point, because they just takes the figure on the machine based figures. So in the present case, the tribunal allowed the appeal of the assessee and said that the assessee has to first claim the exemption under section 54F from the long-term capital gain, and then if any loss is there, on the sale of some other assets that can be carried forward. At the end of this video, once again I am repeating the name of the case. The name of the case is Niklesh Bhagwan Das Mehta versus Income Tax Officer, and this case is reported in 138 ITR Tribunal, short notes 19, and the date of the judgment is 15th April 2026. Thank you friends.